Hi, my name is David Fleck. I am a California attorney, and for the last 2 decades, I have primarily handled cases involving real estate fraud. In many of those cases, notaries were the most important witnesses to prove criminal conduct by con artists because you are the gatekeepers against identity theft and forgery in important transactions. Because of my background, notaries sometimes ask me if they can get sued even if they don't do anything wrong. The short answer is yes. Now, I know from experience that the notary is almost never the guilty party. Instead, in most cases, they were deceived just like the other parties were. Unfortunately, if something goes wrong in a real estate transaction, the victimized parties often assume the notary was either negligent or a co-conspirator in the wrongdoing. Most people don't realize how easy it is to forge documents, signatures, or even notary stamps, or how easy it is to obtain a fake ID that's so realistic that the notary can only spot it with the assistance of technology. So, people wrongly assume the notary was sloppy or intentionally turned a blind eye in cahoots with the scammer. But there's an important reason thieves don't typically partner with notaries: greed. They don't want partners in their scams because they don't want to share the loot. Consider this. In a criminal case, investigators develop evidence first and then file charges. Police detectives have legal tools such as search warrants, which they use to gather evidence and build their case. They can then use that evidence as the basis to file criminal charges. In a civil case, the process is flipped. Plaintiffs must file the lawsuit first and develop evidence second. You see, civil plaintiffs can't get a search warrant like police can, so instead they just have to make their best guess as to who did what. It's only after plaintiffs file a complaint that they are then able to proceed with subpoenas, questioning, depositions, and so forth, and find out what actually happened. It's not unusual for a notary to be named in a lawsuit simply because plaintiffs want to cast a wide net. In other words, the civil process is sue first, ask questions later. And even with the best outcome, being sued is incredibly disruptive. Given the fact that plaintiffs often name as many parties as they can when filing suit, there may be situations in which there simply is no way to avoid a legal tangle. However, a notary can take steps to take the focus away from themselves and onto the real swindlers. First, keep a detailed journal. The most important thing a notary can do for protection is to keep a journal with meticulous detail. Although not every state requires notaries to do this, a well-kept journal can be your savior if you wind up in court answering questions about a signing that took place months or even years earlier, and you need evidence to show you did your job correctly. Second, know your state's notary laws. In many states, the bar to becoming a notary is very low, and people can become notaries even though they know virtually nothing about their state's notary laws. Jumping on a Facebook group to ask a question isn't necessarily going to get you the accurate information you need. However, your state notary regulating agency should have a website that lays out the requirements for notaries. Look for it. Third, have notary errors and omissions insurance. While most states don't require notaries to have errors and omissions insurance, it's still a good idea to get it. If you get sued, you will need to pay a lawyer to help you answer the suit. Simply saying, "I haven't done anything wrong," won't be enough to get a lawsuit dismissed, even if it's true. Under a notary errors and omissions policy, the insurer is contractually obligated to defend the notary in a lawsuit up to the limits of the policy. Once you take these 3 basic precautions, if you are unfortunate enough to get sued, you should be fine. Good luck to you.